what are the other ways to avoid probate without utilizing a revocable living trust? There are several different ways in order to avoid probate. But when we think about this question and how to answer it, we need to understand all the different ways that you can actually own property or own assets. So let's assume that you own a piece of real property. And without putting the property in the trust, we know that probate will happen. So what are the options? Well, we can put a family member, maybe it's a child, onto the title of that home. It's not a great idea. I never advise my clients to do it because when they become an owner of that property, they essentially bring all of their baggage, claims, liens, potential lawsuits with them. Meaning, if you put your child onto title, they get in a car accident and someone sues them and gets a judgment and they own that property, that judgment attaches to the property. So the other way is, let's say if you're a husband and wife, you can own property with rights of survivorship, meaning if one of you passes away, the other receives it. The survivor of the two receives the interest. But what happens when both of you pass away? And in that scenario, we need what's called a beneficiary deed. So a beneficiary deed essentially says, hey, while we're alive, we own the property, but when we die, we want it to go to this person if they're alive. If they're not alive, then we want it to go to this person. So drafting a beneficiary deed will avoid probate for that specific property. When we switch gears and look at financial institutions such as banks, you need to have the same concept. You need to understand this. Beneficiaries can be designated for the bank account. So it is almost the same as the real property that we just went through. Life insurance, you will be required to list a beneficiary, okay? That beneficiary takes the money from the life insurance outside of probate because they're named. And the same thing is true with those bank accounts. So if you list a beneficiary on a bank account, they will get the money outside of probate. Having a will does not avoid probate. Having a trust does not avoid probate if there is an asset that is not in the trust. So there are ways to avoid probate without utilizing a trust. And if you are interested in examining or having a discussion about an estate plan that doesn't involve a trust, we really need to be specific as to what you own and how we're going to change those beneficiary designations to drop down to whoever it is that you want to have your assets when you pass away. Because if you pass away with assets held in your name, a home, a vehicle over $75,000, a checking savings account over $75,000, any type of retirement or stocks or bonds, any of those that are over $75,000 are going to require probate. So if you don't want to do a trust for whatever reason, and some people just don't like the idea of trusts, they've been told to stay away from trusts, we need to really understand what you own and how you're going to avoid probate with a will and beneficiary designations. And the will is only a backup because remember, if the will has to get admitted to probate in order to transfer something, we've defied the whole purpose of an estate plan. So, your home would have a beneficiary designation that goes to your child. The will might say, hey, anything that I own goes to my child. But if we've done the beneficiary designation on the property and hopefully all the other accounts that you have, the will never becomes relevant. The will only becomes relevant if there is an asset that does not transfer to a beneficiary. And when you pass away, it is frozen or held in your name until a probate is opened up. And that personal representative is given power and authority to access that property bank account and then liquidate it.